And good evening, and thank you for joining us. My name is Ryan Burrows. I'm the Executive Director of the American Kratom Association, and we are joined this evening by Mac Haddo, our Senior Fellow on Public Policy. Although we just met last week, we have had continued momentum and want to update you on Texas and Florida. We will also provide you with the latest on Louisiana and our efforts in the remaining states for this legislative season. Thank you again for joining us, and I will now turn it over to Mac.
Thank you, Ryan, and thanks to everyone for joining us. As a sort of a preamble to this discussion, I think that it's important for all of us to understand that we're in the middle of a battle that is really not about politics, but rather about how the most appropriate way to regulate kratom is in the United States. And obviously, the tension that we have from a political perspective is between the FDA, that has their own view about the safety profile and the addiction profile of kratom, and they're really not as concerned about the science of that tension, but really about their regulatory control and the span of control that they can achieve or at least preserve for themselves. And that really is the heart of the issue as we talk to public policy officials. There's also another aspect to this battle, and that is that we know that because it's an unregulated marketplace, and because the FDA refuses to take steps that are essential to protecting the American public, and there can't be a better example of that than what we at AKA have done over the last 2.5, almost 3 years now, in that we have submitted to the FDA the documentation on more than 75 vendors who have marketed their products, kratom products, using illegal therapeutic claims that are in direct violation of the Food, Drug, and Cosmetic Act, which says that you cannot, as a vendor, make an illicit claim if it's not supported by, in this case, a new drug application. We've submitted those complaints with full documentation to the DA or to the FDA. Now, remember, the FDA is the one that says that kratom is dangerous, and their principal objection today that they articulate is that kratom is being used by some people that are kratom consumers to self-medicate in order to avoid the use of opioids. And that when marketers sell their products using those claims, they are incentivizing people or encouraging people to use a product and to purchase that product for their own economic gain to the detriment of their health. If that were an honest decision by the FDA, then why is it that in the 75 cases that we have submitted to them in the last 2.5 to 3 years, there's not been a single prosecution? If the FDA truly were interested in protecting the public health, that's what would happen. And in the midst of that, you have this blanket of confusion that now exists in the marketplace today, that when a person that is using a kratom product takes it and has an adverse event or a fatality that's associated with it, the FDA would tell you, oh, well, this is because kratom is a dangerous product. But even they admit privately that it's really adulterated kratom products. The Secretary Becerra concluded in a letter, Secretary of HHS, to Senator Mike Lee of Utah and Congressman Mark Pocan back in March of last year, that based on all of the evidence that he has seen and reviewed from the FDA, that in fact the fatalities are associated with polydrug use or adulterated kratom products. We know from the science that any overdose from kratom itself would be a rare event, if at all. And then, as Dr. McCurdy has articulated, it may be as yet an unrecognized or undiscovered ingredient in these products of a newly developed dangerous substance that's being added or spiked to it. None of us can know for certain when the FDA refuses to do their job and they leave these families in the extremely difficult and unfortunate position of having to find answers based on the misinformation that they are circulating, where they believe that their loved ones were lost because of ingestion of a kratom product that was pure kratom. Science doesn't support that. And if it did, we would let the science take us to that pathway. But it hasn't to this point. And in fact, all of the science points towards these unfortunate circumstances, both with adverse events, serious adverse events, and fatalities that are truly associated with adulterated products or the polydrug use that people find themselves trapped in. And in that context, that's where the battle comes, because we know that these well-intentioned people, largely well-intentioned, some of them are doing it for other reasons that are really financially motivated, in some cases primed by trial attorneys that get them to file litigation in order to enrich the trial attorneys. We find this unfortunate distinction that is made to public officials, where family members will claim, oh, well, you have to ban these products in order to protect families because our son or daughter or husband or wife or whatever the family relationships are, grandson, granddaughter, died from kratom use. The science does not support that conclusion. And that's, of course, the terrible circumstance that we find ourselves in, and that legislators have to wrestle with. Because when they have a constituent that comes to them and makes these claims, they're not in a position to dissect the actual autopsy report. And by the way, as unfortunate as these circumstances are, when a person steps up to the podium and makes a claim like that, they should prove it. Because as I've invited all of them to do, that if you'll provide us with the autopsies and the tox screens, we'll submit them to an independent toxicologist or forensic toxicologist to make a fair evaluation so that we can all find the truth. And unfortunately, that has not been taken, it's not been accepted. People obviously have different motivations for it, some of them sincere and some of them insincere. So we have to deal with this in the public square, in informing policymakers about what the science tells us. We rely upon the Centers for Disease Control and their evaluation of kratom fatalities. We rely upon other independent sources to evaluate those things. And at the AKA, we're just as interested in finding out the truth as anyone else. When we talk to legislators, this is where the fundamental conflict comes in. In the state of Louisiana, for example, the Louisiana law uses the very same 8 factors that are embedded into the Federal Controlled Substances Act to determine whether or not a substance is schedulable. And that's an important criteria because it is scientifically grounded. It requires that the evidence and data that's used to demonstrate that a substance should be scheduled has to go through a rigorous evaluation of whether or not the substance is in fact dangerously addictive, whether it poses a safety hazard, and then the criteria that is underpinning all of that is evaluated. The one thing that is often misunderstood and mischaracterized to state legislators is that family members will get up and say, well, the reason why you should schedule this is because the FDA has not found an approved medical use for kratom. That's true. And the reason it's true is that no one to date has gone through the entire new drug application process, which takes a substantial amount of money, in many cases, billions of dollars, and 10 years of time. There is no incentive to do that if there is not a marketplace at the end of that exercise. But to suggest that a substance is schedulable because it does not have an approved medical use, this completely dissects the entire purpose of the Controlled Substances Act and the underlying state statutes that mirror the Federal Controlled Substances Act, which means is that first you have to prove that the substance is dangerous and that it is deadly, causes fatalities singularly on its own. And you have to prove that it is dangerously addictive. And then if you prove those 2 things, then as a condition for the third to kick in, and it can have no approved medical use, because if it does, it goes to the other 5 schedules below. And that's the distinction that is often lost and mischaracterized by critics of kratom as they make their case before the public. That's unfortunate because it doesn't allow for the truth to come out. It allows for merely a mischaracterization of the law and the way it's written. In the state of Louisiana, they have 8 factors in order to prove it. Kratom is not schedulable and under Louisiana law. That doesn't mean that the legislature can't schedule it as a public policy initiative, but it would be inconsistent with the law that they've already passed. It requires rigorous science in order to justify this. And so as the presentation was made before the Senate Judiciary Committee discussing this, you heard what I would say is a good characterization of the science provided by Dr. Jack Henningfield, a good persuasive argument for the public policy about how, given that you can't schedule kratom using the scientific criteria, then you should make sure that you have a public policy framework in place that assures that unscrupulous vendors are not going to be able to manipulate the pure kratom product and to adulterate it with dangerous substances purely to give it a kick or a euphoric high or an addiction level that the natural kratom plant does not deliver. These unscrupulous vendors do it for one purpose, and that purpose is to increase sales of their products. It puts every kratom consumer at a disadvantage. It unfairly competes against pure kratom products, which seem in some cases less attractive to people because of the effect that it has on you. And that's what we're trying to eliminate at the American Kratom Association, those kinds of adulterated products that do pose a public health risk, rather than having the ultimate threat be executed on kratom and all kratom consumers being disadvantaged with a schedule. That's why Nora Volkow, the director of the National Institutes on Drug Abuse, has been so vehement in her defense of kratom being used as a harm reduction tool. There is no requirement that the FDA has to approve any product in order for people to make an independent and informed choice to self-medicate for anything. There are more than 40,000 dietary supplement products that are on the marketplace today that have no approved medical use by the FDA. And yet those products have been accepted by consumers. Many of them are used for the very purpose of self-medicating rather than using a chemically formulated drug for a variety of reasons. Sometimes they're too expensive to use the prescription medications. Sometimes it's just not accessible to them because of a personal belief. They might have adverse reactions to the prescription medication, and so they seek a safer and less invasive therapy to do it. And that's the argument that we took to the legislators in Louisiana. Thankfully, they listened. And despite the outside influence of law enforcement officials who have their own issue with kratom because they believe the FDA narrative, they believe the FDA is right when they say it's unsafe, and they look at the effects of an unregulated kratom marketplace in the state of Louisiana, where they see people are having adverse events, not because of pure kratom, because they don't look for that, they don't test for it, and they don't evaluate it on that basis. They see the effects of bad products that really should be relegated to the dump heap, and they see that as being the face of kratom. And that's why it's important that we regulate kratom with a good regulatory scheme. And I think that the Senate committee members saw the distinction, and they advised the sponsor of the kratom ban that while they were going to recommend favorably the bill out of committee to the floor, that they wanted that sponsor, Senator Kleinpeter, to work with the other stakeholders so that we could come to a compromise on a well-regulated system rather than a ban. The same is true in the House side. We had a very tough vote, 8-7, to get the bill out, but it signaled clearly that even on the House side, there wasn't an appetite for a full ban on kratom, and that close vote, of course, illustrated that. I'm pleased to report that both sponsors of the ban bills are working with us now, and we're negotiating to find an appropriate level of recommendation. It requires some compromise on our part, where we're going to agree to levels of regulation that are not typical in the Kratom Consumer Protection Act, but are appropriate in order to protect the Louisiana consuming public, of which there are a significant number of kratom consumers, from being subjected to that. So we expect in the next 48 hours that we're going to be able to conclude those negotiations. It will culminate with a hearing before the House Health Committee on Wednesday morning at 9 a.m. Louisiana time. And that we hope that every kratom consumer that's able to show up for that hearing would do so and enter in either a green card to support the Kratom Consumer Protection Act, which is what this hearing will be on. It's Representative Godot's bill. And that will oppose all of the bans. And between now and then, we hope to have come to a resolution with the ban sponsors so that we can find a legislative pathway for the amended bill that will be passed by both houses and signed by the governor in the state of Louisiana. So that's the current status of Louisiana. And glad to answer any questions before we conclude tonight about the specifics in Louisiana. But we want you to continue to advocate as strongly as you can with the legislators on the House Health Committee and the House members themselves and Senate members when we get to that, once we get to a negotiated legislation that will work. I'm pleased to report that the progress that Ryan that talked about earlier in the state of Texas. Texas is a huge market. It has all of the kind of tenets that you expect to see in a blue collar community that relies upon kratom for its pain relief effects, for its energy boosting effects. These are people that work in ranches and farms, and a huge component of kratom consumers. And the legislature appropriately passed the Kratom Consumer Protection Act, and it was presented to the governor. The governor was bombarded by the FDA's disinformation on kratom. They received concerns from some of the family members who believed that they lost a loved one because of kratom. But in the end, Governor Abbott made the decision that he was going to allow the Kratom Consumer Protection Act to be enacted into law. And we're grateful for that decision because it now sets the stage for the Department of Health to work on the appropriate regulation scheme. But that was the 10th state to enact the Kratom Consumer Protection Act. And that's great news for the kratom community. Similarly, in the state of Florida, the legislature ran into a buzzsaw with the Department of Agriculture, which through the proposed KCPA was the designated agency that would regulate kratom in the state of Florida. Apparently, the Department of Agriculture resents the fact that the Florida legislature has, over the past 8 years, dumped on them, by their characterization, a number of mandates that were unfunded. And they viewed the Kratom Consumer Protection Act as another assault on their agency where they weren't being provided the resources in order to properly regulate another substance that in their view, that the legislature was foisting on them. The truth is, and we had some discussions with the Department of Agriculture, that the Kratom Consumer Protection Act provided a pathway where the funding that was required for it would be drawn from the vendors in registration fees. And if there was a credible report that was provided to the Department of Agriculture in Florida, they could require that the vendor that had registered would resubmit a new and current certificate of analysis on the compliance of the kratom product from an independent third-party lab. That cost would be borne by the vendor. If the department still had a good faith belief and a basis upon which to do the test themselves, they could select an independent third-party lab and bill the vendor for the cost of that lab test, so that there would be no drain on Florida taxpayer resources in order to regulate this product. And the registration fees themselves would be sufficient. The Department of Agriculture came in hot. They wanted $20 million in order to regulate kratom. Now, you contrast that to the state of Utah, which has a registration fee of about $360 per product. They generate just under $172,000 a year based on the number of kratom products that are registered. There is no belief that the state of Florida would register any more products than would be generated, the registrations in the state of Utah. So the same revenue stream, and yet the state of Florida determined that it was going to be a $20 million fiscal note to attach to the bill. It was unreasonable and grossly excessive. After some negotiation, they weaned it down to $10 million. After we amended the Kratom Consumer Protection Act in Florida to have the model for testing that I described, they took it down to $2 million. And then the fiscal analyst said, well, actually, that's still too high. And they came to a $750,000 regulatory fee, which in the end, the Department of Agriculture balked at and said they couldn't do it for less than $2 million. And so what we were left with is a decision to pass the basic framework of the KCPA and allow for a negotiation to take place with the Department of Agriculture over the next several months, and then in the next session to actually enact the fee structure that will appropriately reflect what the actual costs would be for regulating kratom in the state of Florida. The state of Florida is now the 11th state to pass the Kratom Consumer Protection Act. And so we're again grateful for that. We're making progress here. We are still working in a number of other states in order to secure the passage of the Kratom Consumer Protection Act. The state of Missouri is winding down their legislative session. The governor has made it clear that he's going to veto the KCPA again. He doesn't get the argument that you have an unregulated marketplace today, and that's vastly more dangerous than any kratom product that would be properly regulated would present to the Missouri public. So we continue to work hard on that. We're working in Illinois, in Wisconsin, in Minnesota, in Michigan, in Ohio, Pennsylvania, New Jersey, New York, Massachusetts, Rhode Island, and in Vermont. And we also are working in North Carolina, in order to get the KCPA passed. The state of South Carolina had a kratom ban that was proposed. The sponsor, just before the crossover date, which means the date upon which the legislation had to pass out of the House over to the Senate in order to be considered in this legislative session. And despite a significant number of co-sponsors on the kratom ban legislation, they did not move the bill from the House within the prescribed time frame. It still could get resurrected with some rarely used procedure in South Carolina, but that's highly unlikely. Our lobbyists are watching this carefully, and we're working closely with the sponsors and a number of the co-sponsors in order to educate them about the Kratom Consumer Protection Act. And so far, they're being very receptive along the way. We know that there was a kratom ban that was proposed in the state of Georgia. We successfully negotiated that to a regulatory scheme similar to the KCPA, strengthened on the existing legislation. That bill was deferred by the Senate. They didn't take it up. And so we're working now with the regulatory agencies there, looking forward to passage in the next session of a strengthened KCPA in the state of Georgia. In the state of Montana, we had a kratom ban bill that was filed. It made it through the Senate in a last-minute secret deal by the Senate president and some of the sponsors in the Montana Senate, in which the bill was inserted in a committee hearing in late afternoon, went immediately to the Senate floor. It was added to the drug control bill that adds dangerous substances to the controlled substances list. They went to what's called second reading that afternoon. The next morning, they took it to third reading, which is final passage in the House. We had to scramble over a 2-day period, hiring lobbyists and educating legislators, and that resulted in, and part of that education, by the way, are the significant efforts of the kratom consumer public, the advocates, those of you on the call, those of you listening, those are the people that you have rallied. And it made a difference because we all know that the Montana House voted 100-0 to reject the Senate amendment. And that resulted in a conference committee where kratom was struck from the ban. And we're now actively working with Montana legislative leaders in order to educate them about the value of the Kratom Consumer Protection Act, which we expect will be passed in the next session of the Montana legislature. In these states where we're seeing these bans pop up, we're working hard. We know that there were initially 6 states that accepted bans that were advocated for by the Food and Drug Administration. There are only 5 officially that have them because Vermont rescinded their ban. We expect to have the Kratom Consumer Protection Act replace the ban in Rhode Island. We expect the same thing in Wisconsin. In Indiana, a repeal passed with the replacement of the KCPA on a vote of 53-40. It's now in an interim study committee in the Indiana legislature, and that will take place this summer. And in the state of Arkansas, there is a bill that's about to be filed which directly challenges the decision by the Arkansas Department of Health to ban kratom. So we've got a lot of great activity that's going, and the only state where we don't have, at least to date, have not had acceptance of a reconsideration of their ban is the state of Alabama. And I have hope for them once we see these other states fall, which they should, in order to, instead of banning kratom and allowing their citizens to be at risk for black market products, regulate it so they're protected, and that the consumers would have an increased confidence in the products that they're able to go and buy, knowing that they are compliant with the state law that ensures that good manufacturing practices are being followed. So that's a recap of where we are. We'll tell you every day that none of this would happen without the support of the advocacy community among the kratom consumers in the United States. We appreciate your efforts. We know that it can be frustrating because there are people, and they're on this call, they're listening because they embed themselves into it, they're gathering intel. They will tell you, oh, we lost a family member. And we have great empathy for people that have had those circumstances. But as I've said before, and I will repeat again, that everyone in this situation needs to know the truth. There has to be complete honesty from those that they've lost a loved one, if they truly can document that it was not that the medical examiner said it was kratom, but whether the toxicology report and an analysis, much like the Centers for Disease Control did when coroners and medical examiners from around the country reported to the Centers for Disease Control that there were kratom deaths, of which 7 were kratom only. That was the determination made in good faith by medical examiners and coroners. Now, maybe they listened to the FDA. Maybe they trusted the equipment that was available to them to test the blood samples of the decedent. But when when the Centers for Disease Control actually evaluated those 7 deaths that were kratom only, 4 of those had blood samples available that could be tested. All 4 tested for polydrug use, because the medical examiners and coroners, however good faith they came to their conclusion, didn't have the equipment that was necessary to do the proper analytical work to determine what the truth was about those deaths. And so that's why we encourage anyone who claims that they had a loved one who died because of kratom, that they allow it to be subjected to that kind of more sophisticated analytical tool so they will know the truth. And it's not about going and suing someone and getting a payday at the end of the day for the trial lawyers. It's about knowing the truth. And I think that we're committed to that. As Dr. McCurdy has said, it would be rare for there to be an overdose death that's related to kratom because of the pharmacology of it. And it could even be explained once it's been evaluated as a kratom death by some yet unknown substance that is a part of the ingestion of that individual that has to be identified. And of course, we all know that there are common adulterants that are added that make kratom products very dangerous. These vendors do this because they want to make a dollar. They want to exploit the public. They want to take advantage of a consuming public that thinks they're buying a pure kratom product, and they have the effect that when they ingest this adulterated product, thinking it's the pure product, that somehow that's a better product than they purchased the last week or so. And so that's the heart of our problem, and why we're fighting so hard for a regulatory scheme that actually works. So I'm going to stop there, and Ryan, we can go to the questions. I'm glad to respond to any questions that anyone might have.
That's great, Mac. Thank you so much. And a good evening to everyone from John Shinholzer. Also some great comments. Just thank you for your support to Kenny, Michael, and Jeff. We appreciate you being on the call. And Marielle, those of us that can't be there in Louisiana, what else can we do to weigh in our favor besides email? And Ariel, I would just direct you to our email campaigns that we've been sending. You should be in receipt, I hope. And there are more than 100 Facebook links that we're asking everyone to share their testimonials on. My email is ryan@americankratom.org. If you're not receiving that, please reach out, but would be happy to share that with you. From Brian, given what happened in Oklahoma, can we expect to see the FDA continue to confiscate kratom in other markets around the country?
Well, this is a great question, because everyone needs to understand that when a state passes the Kratom Consumer Protection Act, it is protecting the citizens of that state for market entry of a kratom product. It does not supersede federal law. And the FDA, even though they are wrong, is using and abusing an authority that's granted to them by the Congress for import alerts. They don't have the authority, and Dr. Zawaz said it perfectly, the FDA does not schedule substances, the DEA does. And because the FDA cannot prove their case to the DEA, they cannot schedule kratom because it's unschedulable under the criteria that's required for scheduling under the Controlled Substances Act. But all that the state does is say that if a product is sold in that state, it meets these standards in order to be compliant, which is to make it pure, not adulterated, not synthesized, properly labeled, and not sold to children. That's the important thing and protection. It offers no protection from the FDA overreaching on their authority, and that's going to have to be litigated in court, and it will be, because the FDA, as Dr. Jawad said, relies upon disappointingly poor evidence and data. He said that in 2018 in rejecting the second attempt by the FDA to schedule kratom. In 2023, the evidence is stronger. The evidence is more compelling. The FDA cannot win, and yet they use the same tired old rhetoric in their complaint that they filed with the court about the safety profile of kratom, the same evidence and data that Dr. Jawad rejected in a scathing rebuttal, and yet they want to go to a court and say to the judge, well, trust us because we're the FDA and we always do it right. They do not. The FDA is wrong about kratom. They were wrong about dietary supplements in 1994. They told the same people that dietary supplements were killing people, that they were poorly formulated products. And they were right about that, by the way. The solution is not to ban them. The solution is to regulate them. And they said that vitamins and dietary supplements should all be new drug applications. And the US Congress unanimously said no. They told the FDA, we're going to give a regulatory pathway for dietary supplements and dietary ingredients to get into the food supply so that people would have access to and make informed decisions about their health and well-being. The FDA hates it. If they had the ability today to repeal the DSHEA Act, they would do it. And they say it routinely all the time. They will look for ways in order to find impediments to the marketplace for someone that could go out and, God forbid, they self-medicate. They actually make a decision about what they're going to use a product for their health and well-being. And a perfect example of that is the objection the FDA raises to people using kratom to self-medicate against opioid use in order to manage acute and chronic pain. The FDA does not want you making that decision, and they want you on opioids. And what did Dr. Jawad say about that? Millions of people will die because you will force them back to a less safe product that has a very high addiction rate and an overdose rate that is off the charts. That's the problem that we have today. The FDA does not trust the American people, but more importantly, the FDA wants to have that control. Now, part of its control, part of it is the reality that we face today in what in retrospect was a mistake by the US Congress to incentivize the Food and Drug Administration to regulate the new drug approval process by accepting user fees from the pharmaceutical industry. It started out about 9% of the revenues to the FDA in the drug development process, in the drug review process, was contributing financial resources so the taxpayers didn't have to do it. Companies were paying it. Today, it's almost 70, or maybe it's just a little over 70%. That is a corrupt system because it incentivizes the FDA in order to force everything into the new drug application process so they can collect those user fees. They're not collecting them from dietary supplements. And that's their beef with this. Even if they're right, and they're not, even if they're right, they ought to fairly evaluate kratom on its merit. So what does the FDA do? The FDA has the authority under the DSHEA Act to evaluate kratom unless we can prove it was in commerce prior to October 15th of 1994. The FDA says everything has to go through the new dietary ingredient notification process. Now, here's the interesting thing. They tell the courts, and they will have already told the courts in their pleadings, that the seizure of the kratom products, because they're adulterated per se, because they do not have a registration as a new dietary ingredient. Well, they're the judge and the jury on that. The only way that any company can get a new dietary ingredient notification registration is with the approval of the FDA, or the acceptance, I should say, of the FDA. The FDA has not accepted a single NDIN, and they won't, because that's their way of having a de facto pocket ban on kratom going forward. So they use the NDIN process to deny it, and now they're reaching out to use the import alert process to do the same thing. It is a corrupt system that needs to be corrected by the US Congress, and that's why the federal KCPA is going to be so important to us as we move forward in that process.
Great, thank you, Mac. And any way to know which kratom producers that have adulterated their product so we can boycott those companies?
Well, you can look at the ones who are making illegal therapeutic claims. Now, that doesn't mean those products are adulterated, by the way. It means they're mislabeled. And they're mislabeled for the purpose of incurring an economic incentive by selling more of their products. The fact of the matter is that everyone is at risk in an unregulated marketplace from adulterated products. And so it's very difficult for us to know, or anyone to know, which products are adulterated. There are products that are being sold as some of the leading brands out there that are knockoff counterfeits that are adulterated. They're made to look like one of the leading brands, and you think you're buying that. And then people say, wow, great effect from that. Well, it's because it's adulterated, spiked with other substances that are designed to give you a euphoric high because it's better than what the natural plant provides. So if you take a product, a kratom product, and you have this sensation that it's giving you a euphoria that's associated with an opioid as opposed to kratom, then you need to think twice, and that's probably an adulterated product. We do regular assessments, and we encourage anyone who has a product that they suspect is adulterated to send it to us so that we can have it tested and we can find and identify these bad actors. Here's the bad news about that process. We've already turned over documented cases of kratom vendors who are violating the law, and the FDA has not prosecuted one of them over 2.5 years. That's a disgusting outcome of a regulatory agency whose charter is to protect the American public. And they complain publicly that people are self-medicating, and they won't go after the very people who are telling consumers that they should use these products to self-medicate. Does this make any sense to anyone other than the FDA? So this is a tough problem for us to do. And by the way, when they pop up and someone identifies an adulterated product, they go away and they just do it with another product. So we have to be constantly vigilant in making sure that you buy from reputable vendors, vendors that have been willing to submit to independent third-party testing. That's one way to do it. And I'll tell you, there's another potential problem in the current kratom marketplace. It's about price. There are farmers in Indonesia who are sending kratom raw materials to small and even large vendors here in the United States that are not testing their product. They'll tell you they're testing it, but I can tell you I've been there. I've seen the way they're handled. I see the way they ship them in the local distribution. There is no testing going on. And you are being put at risk, even though they swear by it, that they're testing them for Salmonella, E. coli, and heavy metals. And that's a ticking time bomb. That would be eliminated if we had a standard that the Kratom Consumer Protection Act provides to require that a vendor submit independent certificate of analysis from testing that's been done in the raw materials used to manufacture their finished products, and then compliance with the dietary supplement law, which requires all finished products to be tested at the production line in order to make sure that they're compliant. That's the way we protect the kratom public. But the kratom consumers that are looking to find the cheap products, and those cheap products are cheap because they don't have to compete against the companies that are actually buying the equipment to make sure they're manufactured properly, invested in the testing, having the operating standards in place, the SOPs that are required for compliance under FDA, good manufacturing practices. If you don't do that, your product can cost less. And by the way, they're probably selling you some very poor quality kratom. I know that many of the farmers over in Indonesia are upset with the effects of the import alert, which means no one's paying them advance for their product. So they just sort of, they gild the lily. They put in non-kratom materials into botanical products and they ship it as kratom. And what you find is that there is no kratom or very little kratom in it. And that, of course, results in very poor products. The Department of Agriculture in Utah said that one of the interesting things that they have seen is not so much in the state of Utah when there is a specific penalty for an adulterated product, they see kratom products that have no kratom in them, whatever. That's a tragic outcome of a marketplace that's unregulated without untested products. And I get it. I get it that we want cheap products. The price is important. I get it that the small vendors say, I can't afford to be in business. They tell me all the time, I'm trying to put them out of business. I am, if they're not willing to be compliant. This isn't about the vendor. It's about consumers. And it's about protecting consumers. And it's about doing what's right in this marketplace to protect the continued availability of kratom products in the United States. And that comes with good regulations and vigilance on our part and rejecting those vendors that are selling kratom that is just on the cheap because they're not testing it and because they're not labeling it properly. They're not manufacturing it properly and they're not testing it. It's crazy. And we need to stop that nonsense and do the best we can and accept that a well-regulated marketplace may produce kratom products that are a little more expensive, but they're safer. And that's the bottom line.
Thanks, Mac. And a comment from Troy. Thank you, Mac. I'm working offshore right now, but we'll be home tomorrow. I'm only an hour away from the capital in Baton Rouge. I will do my very best to be there. Thank you for all you do. You're absolutely amazing.
Well, thank you. I will see you there. We're going to have Senator Bramble will be there to make our arguments, and John Schinholzer, who is a magnificent advocate for protecting those people that are in the addiction recovery community to ensure that they have access to products that actually work. And for those people that find that Kratom works, they should have the freedom to do that as well and not be interfered with by a bureaucrat in Washington that just wants to attack Kratom rather than accepting it for its potential benefits. So we welcome John being there. Everyone should tune in and watch. If you aren't able to make it, we think it's important that you see the fight we're taking, the message we're delivering, and we're glad to have John on our team. He's a magnificent individual who's helping us.
Excellent. And from Stephen, would the Florida KCPA void Sarasota County, Florida's prohibition?
It will not, but the state senator who sponsored, Senator Gruters, who sponsored the Florida KCPA, represents Sarasota. And he and I have talked about this issue. He is prepared to go to the county government with the passage of the KCPA and encourage them to drop the ban. We've had discussions with the commissioners and with the sheriff's department, and we think that they'll be inclined to remove that ban once the KCPA is signed by the governor.
And from Robert, the two major political parties in the USA, which one or the other is trying to ban Kratom, and which would be in favor of its availability and regulation or safety? Wish I didn't want to ask this.
So here's the answer. When you have in 2016, Senator Orrin Hatch, who was one of the most conservative US senators in the Senate, and Bernie Sanders, who is the most liberal member of the United States Senate, not even a Democrat, an avowed socialist, willing to fight for consumer access to Kratom, that tells you all you need to know about the political philosophies that are guiding this policy. And today you have Senator Mike Lee, who filed the Kratom Consumer Protection Act at the federal level and will refile it in the new Congress, along with Senator Booker. And those two are at polar opposites on the political spectrum. And you'll see the same thing with our House sponsors. This is not a political party issue. This is about an outrageous act by a rogue agency that has been given too much power in Washington in the form of the Food and Drug Administration that's decided that they can abuse their regulatory authority in order to enact a ban that they cannot and do not have the authority under statute to do under the Controlled Substances Act. They're acting out like a petulant child. They're not willing to do what they should do to protect the public, and they're just trying to get their end game, which is to ban a substance that they don't happen to agree with. And I've articulated why some of those things may be true. Even if it were something that they genuinely came to the conclusion early on was a problem, when the evidence and data was submitted to the FDA in a meeting by leading scientists on what they called the oxycodone protocol rat study was presented to them. And by the way, this study was done using the FDA's own oxycodone protocol, which is used for all substances that are in that spectrum to determine the safety, relative safety. They know exactly what happens with the oxycodone protocol for the rats. They know at what levels the rats will die. When they matched that against Kratom, the first tranche, they had 3 dose levels. The first dose level, everything was expected in terms of sedation effects and the opioid effects of the oxycodone on the test animals. The dose matching the oxycodone protocol for Kratom showed no effects whatever. No blood oxygen suppression, no respiratory suppression, nothing that was impairing the animals. And so the researchers recommended, if I had been in control of it, I would have said no, because I would have thought we just want the result, right? They came to the team and said, look, we're seeing nothing, so we think you should boost the metrogenine levels in the next tranche of the dose. So instead of matching the oxycodone, they went higher. And so they did that. And they came back, and now you had some deaths. You had all of the effects of oxycodone that were predicted and why the FDA uses that as their standard. And they came back and said, still nothing. and you're not going to see anything. So they recommended that the scientists allow them, that were supervising the study, allow them to go to the highest level of metrogenine that could be put into an aqueous solution to inject into the test animals. 400 times or almost 400 times of what a human could consume in a day. The oxycodone rats died, and nothing with the metrogenine animals other than sedation, which would be expected at that level. No deaths and no adverse events that were significant. That was matched, by the way, by a human clinical trial, which has now been presented to the FDA. They don't care about the truth. They know about this. They know about the oxycodone study, rat study. They know about a human clinical trial that is powerfully demonstrative of the safety of kratom, and they're still out seizing kratom, making the same arguments to a judge, lying to a judge, arguably, about kratom. It tells you the bad state of affairs we're in. So this is not political. This is about a rogue regulatory agency that needs to be reined in by the Congress in the form of the U.S. Food and Drug Administration, who by most accounts does magnificent work. But this is one they have a blind spot to, and they're not going to give it up. And so we need to force them in a court of law in order to make sure that they're accountable to the American people about a substance that is really a harm reduction tool, as Dr. Volko at NIDA document and testifies that it is under oath.
Great, thanks, Mac. And from Kenny, so you can confirm there are active negotiation willingness on the part of Senator Kleinpeter and Representatives Furman and Edmonston with Representative Goudreau. Can you give us an idea of how confident you are about there being a compromise other than Schedule 1? This is going to determine many people's future. I know anything is possible, but how are we doing with negotiations relative to other states that we've passed the KCPA? How are we looking going into Wednesday?
So the answer to that is difficult. I would like to say that I have a very high level of confidence that we are going to be able to negotiate something here that will be acceptable. I say that from experience because we faced similar challenges in other states. We would not be in the position of negotiating this, but for the efforts of the kratom community in advocating and in competing against the voices of those critics. And that takes the form not only of the folks that are arguing against kratom being unsafe, and they claim that they've lost family members to it, but also the powerful voices of the sheriffs in Louisiana who are listening to the FDA and listening to these family members without really truly evaluating all of the scientific evidence. I think that the Senate Judiciary Committee members made a very important choice after listening to the testimony that was presented, and after listening to the voices in the kratom community who argued that kratom was actually helping them, in some cases saving their lives. That voice needs to continue, and it will enhance our ability to come to a negotiated settlement here. The most significant thing that happened in the Senate vote was, despite the fact that they passed it out with a favorable recommendation, they did it with the caveat that Senator Kleinpeter had to meet with Representative Goudreau and negotiate a compromise here. The ban was not going to be acceptable. It had to be a regulatory scheme that would protect the citizens of Louisiana. So I'm confident that we'll come to some agreement. It may not be something that we all like in terms of being 100% we're there, because that's the art of the compromise, is to find ways to work together. But what we will at the end of the day, I believe, have a regulatory scheme that will preserve access to safe kratom products for the citizens of Louisiana. It should do that. That's the good public policy. And I think that we'll find a regulatory scheme that will be acceptable to the sheriffs and to the legislators that will preserve and protect our ability to allow for kratom products to be sold there. I can't guarantee anything, but I can guarantee you this: we're going to be in there fighting hard to protect the kratom consumers, and we'll spend most of the day tomorrow, and certainly on Wednesday when we have the hearing, we'll know whether or not we have a deal. They passed on the votes today, both in the House and the Senate, and that's significant because it indicates that they're willing to have these discussions, and now they're ongoing. We've already been conversing back and forth, and we have another call first thing in the morning. I think we're in a pretty good shape right now.
Great, thank you, Mac. And just a quick update on South Carolina for Misty.
I mentioned earlier, South Carolina missed the crossover date for the House to have acted on the kratom ban that had been proposed, which means that it is not actionable unless, and this is a very rare occurrence in the South Carolina legislature, akin to Lazarus rising from the dead, a senator could re-raise the issue, but then it would pass the Senate and the House, and they're rapidly running out of time. My understanding from discussions that our lobbying team has had with the legislators down there, that they are persuaded that a ban is not going to work, and that they're looking for solutions, and we're educating them on the KCPA as we speak.
Excellent. And an anonymous comment, how can people still legally make claims that it may help with energy? Again, my email is ryan@americankratom.org. Please send me your information regarding this, and I will share some documentation with you on some labeling guidance. Also, our new GMP 3.0 program will include that as well.
And no vendor should be making any structure function claims without the benefit of an NDIN that is accepted by the FDA. No kratom vendor should be making a therapeutic claim that's illegal under the Federal Food, Drug, and Cosmetic Act without the benefit of a new drug application approval from the FDA. You can't do this. And by the way, it's what you market on your label, and anything on a website, a blog post, a social media post, Facebook page, Instagram, TikTok, anything, that is all associated with the product if the innovator or the manufacturer is the source of that material. If you want to know about the potential therapeutic benefits of kratom, come to the American Kratom Association, listen to the testimonials that we post there, and we're allowed to do that because it's a free speech right. We don't sell kratom. We are in the process, we're in the business of educating consumers, and everybody should understand that kratom can be something that's useful to maintain your health and well-being, but you should do so with the advice of your doctor when you use kratom, particularly if you're using it for a therapeutic benefit. Make sure that the other medications you may or may not be on are not going to be contraindicated. Make sure that it's safe for the health conditions that you have, and make sure you do it in moderation, test it, and as you use kratom and find benefits from it, that's fine. That's part of the dietary supplement system that we have in the United States today, and it's perfectly acceptable. But the vendors can't be the ones to trigger that kind of information flow to you, because that's illegal under federal law.
Great. And a quick update on Tennessee and Michigan.
So Michigan, I just talked to our lobbyists there today. We are struggling with educating the governor there. We've got the legislative process in play. The governor's people have some issues that they're working with the FDA on, and of course that's the wrong source of information. So we're trying to fix that, and I think that we're going to continue to do. What was the other state? We had Michigan and
Tennessee.
Oh, Tennessee. So in Tennessee, we had a great conversion of the majority leader in the Tennessee House, who previously last year had sponsored a ban on kratom. And I think that to his credit, he evaluated kratom, he looked at the science, and he came our way. We now, and it clearly was going to pass the House. We went to the Senate, and the Senate chairman there of the Senate Judiciary Committee is all for a kratom ban. He hasn't been up to now willing to listen. In fact, he did a very unusual thing at the conclusion of the hearing in the Senate in Tennessee, and that is he instructed the clerk that he was going to vote first. It is customary for the chairman of the committee to vote last, particularly in the case of where there may be a tie. He directed the clerk, I'm going to vote first on this, and he voted against the KCPA as a signal to his members. And we talked to many of the members of the committee that said we only did it because the chairman was adamant that he wanted this banned. Now we have already opened up discussions, and we think over the summer we're going to be able to do what we did with the House Majority Leader to convince him that what he's left the state of Tennessee with, and there's a little bit of a twist to this, is a potentially unsafe marketplace that's completely unregulated. Now, Tennessee currently has a law in effect that bans synthesized kratom products by ruling of the Attorney General on a previously passed piece of legislation. So there's already a level of protection that other states don't have, that don't have any regulations. But we want the KCPA to be a part of the Tennessee legislative and their statutory structure, and we're going to work hard to get that state next year.
Has anyone come forward with proof of kratom use prior to 1994?
So this is a central issue we've talked about for years. It doesn't mean that the evidence doesn't exist. If you look at the guidelines that are published by the Food and Drug Administration, in order for a product to be deemed to be generally recognized as safe and in commerce prior to October 15th of 1994, there is a test for it. The company that was targeted by the FDA for action made an announcement that they were going to offer a reward for anyone who could demonstrate or produce evidence that would be accepted by a court to meet the standards set by the FDA, which includes things like published ads that advertise for the sale of kratom prior to that October 15th of 94. And there's a substantial reward for finding that. We think that's great. If you can avail yourself of that, if you have information, it requires that if you can't find an advertisement, that you have a sales slip that's generated by a reliable and verified software system, which is very unusual prior to 1994 for even big box stores to have that kind of system, and certainly wouldn't be for mom and pop delis or smoke shops. So that's been a challenge. But as you scour your records and you look to see, you know, where did you buy kratom prior to 94, or where did your associates or family members, and you can go back to those stores and you can unearth this kind of evidence. That would be the one way of addressing specifically the objection by the FDA that the kratom is not covered by the pre-1994 DSHEA exception as a GRAS substance that was in commerce. We know it was. We just have to find the proof that allows us to do it, and I think we're scouring the landscape for that evidence.
Thank you, Mac. And I believe we've answered the majority of the questions this evening. There are a couple comments. I just want to remind everyone that the hearing will be in Louisiana, will be Wednesday at 9 a.m. in Committee Room 5 with the Committee on Health and Welfare. There's a louisiana.gov website where that link is available. And Mac, did you want to make any closing comments this evening?
Well, just thank you. Thank you to everyone. We're in a battle, and you see it every day with the reaction of the FDA to try to squash this marketplace. And they do not care about the consequences of it. They don't listen to Dr. Nora Volkow at NIDA that says that this is a valuable harm reduction tool that should be accessible to the American public. We need to keep fighting. I know, I mean, I can personally attest, this is a battle that can be fatiguing, but we can't let, the onslaught of these attacks to wear us down. We've got to keep fighting, and we're deeply appreciative of everyone who stands up every day. I see it on Facebook groups. I see it as people testify. There was a young lady that testified in Louisiana last week, obviously not comfortable with doing so. She was near tears, but hers was a powerful statement, a powerful testimonial. And I'm telling you, it moves people. And so everyone should please be vigilant, pitch in. Don't assume that we're going to win every battle. We've had some close calls this year, and we're going to continue to see them because the voices of well-intentioned people who think that they've lost a loved one, those are powerful voices, and I feel for them. And I know they don't like me, and they think that the AK is awful, but they're wrong, because we have the interest of the public at heart as they do. They've suffered a horrible loss, and certainly that's hard to reconcile, and nobody can replace a loved one. But I think we have a common interest in finding the truth and protecting people going forward. And if you can't schedule kratom, then you should regulate it. And I think every one of those families ought to be interested in doing that as well. So I hope that all of us can continue our diligent efforts to communicate with legislators to protect kratom in the states in which they live. And the more states we add to the KCPA, the more difficult it is for the FDA to keep their onslaught of regulatory abuses in check. So thank you.
Great. Thank you so much, Mac. I want to thank you all for joining us. And we will update protectkratom.org/Louisiana with the link for Wednesday's hearing as well. Again, reach out to me, Ryan at americankratom.org, if I can answer any questions at all that we didn't get to this evening. And we will be in touch in the coming weeks with more updates. So thank you all.